Okay, we're going to get started. Welcome to the Real Estate Services Program webinar on co-marketing in a digital age under RESPA. This is Sarah Young. I'm the Director of the Real Estate Services Program in NAR. And as many of you know, we decided to offer this webinar because we've received so many inquiries from members with concerns related to co-marketing. I'm also joined here by Christy DeSanctis, who is NAR's Business Issues Policy Representative, who also works closely on RESPA issues. We invited our guest speaker today, Mitch Kiter, who is the Chairman and Managing Partner of Wiener Brodsky Kiter, to discuss some policies and procedures for co-marketing arrangements that settlement service providers can put into place to comply with RESPA. In his 35 years as a practicing attorney, Mitch has represented banks, mortgage companies, residential home builders, real estate settlement service providers, credit card issuers, and other financial services companies. As a litigator, Mitch has defended clients in more than 150 class action lawsuits in federal and state courts throughout the country. He also advises clients on federal and state regulatory compliance matters. Mitch represents clients in investigation enforcement actions before the Consumer Financial Protection Bureau, Department of Housing and Urban Development, and many other agencies. Mitch also acts as outside general counsel to smaller companies and special regulatory and litigation counsel to Fortune 500 companies. He has written extensively on issues involving lenders and other settlement service providers and speaks frequently on regulatory and litigation matters before trade associations and other industry groups. So we are so excited to hear from Mitch today. But before I turn it over to Mitch, I just want to note that you'll all be muted during the webinar, but feel free to use the Q&A function to ask questions at any time during Mitch's presentation. And Mitch will probably pause at times during the presentation to make sure there aren't any questions. Depending on the number of questions that we get, we might take some at the end. We'll just have to see. But again, use the Q&A function and we'll monitor them as we go along during the talk. We also sent a copy of a RESPA do's and don'ts card on co-marketing that we worked on with Mitch, and that was distributed in advance of the webinar. If you did not receive a copy, please email me after the webinar to make sure that you get that. We're also going to post it on nar.realtor later in the week. Christy and I also will be meeting with the CFPB on Thursday about this issue, so if you have specific questions that come up as part of the webinar, feel free to email me offline. It's scyoung@realtors.org, and we can make sure that we put your questions into the discussion with the CFPB. The webinar will also be recorded today for those who could not attend. So if you have colleagues that couldn't listen today, we will make the recording available later in the week. So Mitch, I'm going to go ahead and unmute you now, and we can get started.
All right, great. Thank you, Sarah. Thanks for that introduction. And hello, everyone. It's good to be here with you today, and thank you for spending some time with us. In my 36 years of practicing law, I think it's fair to say that I've dealt with RESPA issues almost every day, literally almost every day. As you know, RESPA is a 43-year-old statute, but it's an all-inclusive, all-encompassing, very broad statute. And it's a statute that, in large part, governs your relationships with all other settlement service providers. That includes your relationships with lenders, with title companies, with settlement agents, with appraisers, and that's just to name a few. And as a result, RESPA is a statute that regulators can and always have used in the past to dictate how you can conduct your business with other parties. As I'm sure you know from the onslaught of litigation and enforcement activities that you've been reading about, RESPA has teeth. It has both civil, administrative, and criminal penalties and sanctions that's available to it. Now, at the conclusion of this webinar, NAR will send you a more comprehensive deck, which we prepared, which will include additional background on RESPA for your review. But for today's purposes, we're going to focus on some of the more recent pressing issues in RESPA. We're going to talk about co-marketing with other settlement service providers. We're going to talk about social media marketing and the use of social media. And along those particular lines, in both of those categories, we're also going to be talking about buying leads, sharing leads from third-party portals, leads that were purchased from third-party portals, and whether or not you can share them with other settlement service providers and how one would otherwise pay for those leads. No doubt that after reading about the CFPB's unique interpretation of RESPA set forth in their position on the PHH case, and no doubt that after reading about the more recent consent order with Prospect Mortgage and 2 real estate brokers, you're wondering just what can and can't be done in the 3 areas I've outlined for you. And that's what I'm going to do today. I'm going to jump into what can and can't be done. And by way of truth in speaking, let me just say that I have represented PHH in their case since its inception, and I am still one of the attorneys on the PHH case, working on the appeal and arguments to the Court of Appeals en banc. And I represented Prospect Mortgage in the case that many of you, in the consent order that many of you are thinking about right now, that raised a number of these issues about co-marketing itself. So feel free to jump in, ask questions, let me know if there's something else you need or something that you don't understand. But why don't we just jump right into it right now, and let's get started with co-marketing. And let's start that with this one basic tenet. Co-marketing with other settlement service providers, such as mortgage bankers, lenders, co-marketing is not illegal. You can, in fact, do it. You just have to do it right. You have to do it in a way where the consumer knows that what's happening is that there are 2 or more parties that are advertising themselves and their products, that it is not an endorsement that one party is making of another, that is not a referral that one party is making to another as well. You also have to do it in a way in which, by co-marketing, you are not picking up the marketing expenses of your partner in that particular venture, and they're not picking yours up as well. So what am I talking about here? Well, in the context of co-marketing, it's really as follows. If you take a look at the slide here, co-marketing occurs when 2 or more parties are each represented in one marketing piece. So let's say you're on a flyer and there are 2 parties on the flyer, and let's say there's a real estate agent and a loan officer, or there's a real estate broker and a mortgage lending company that are each advertising on that piece. That is, in fact, co-marketing. And you can be represented online in the same way on a website and co-market along those particular lines as well. Now, the marketing party can either be one of the co-marketed parties themselves, they may own that medium, or it can be an independent third party, such as a third-party website host, or, a newspaper, for example, is in fact an independent third party that is providing the medium on which you can, in fact, go ahead and co-market. The CFPB hasn't yet extended its rather unique and sometimes bizarre understanding of Section 8C2, which provides that notwithstanding anything in Section 8A and 8B, you can pay someone for the value of services that are rendered, despite the fact that you may also get a referral. They haven't gone beyond what 8C2 itself says when it comes to the context of co-branding or joint marketing efforts themselves. And that's why we do believe that you can, and you have support by way of statute, by way of regulations, by way of interpretive rules for co-marketing and doing it if, in fact, you're doing it properly. There is always the added complication when we deal with co-marketing in the context we are today, and that is when there are 2 settlement service providers, because the CFPB seems to maintain the position that if there are 2 settlement service providers, just by virtue of the fact that you entered into the co-marketing agreement with each other, you have given each other something of value, and therefore if there are referrals that come back and forth, that in fact may be problematic. But I will tell you, if you look toward the PHH case itself, I know you all understand that there's going to be a hearing en banc. I don't think that the court is going to move away from the position of the 3-judge Court of Appeals determination that, in fact, the CFPB's reading of RESPA is incorrect. I think you will find that they will not find that entering into an arrangement for business is a thing of value itself. So let's move on a little bit, and let's talk about what the basic rules are that apply to co-marketing with other settlement service provider. And as you'll see on this slide, there are a number of different rules. So the first one is you have to pay your pro rata share of the marketing. So if you are co-marketing on a website, on a web page, or if it's just a hard flyer page or anything else along those lines, and you're each taking 50% of the space up, you have to pay for 50% of the cost of that particular ad. And how do you determine what that payment amount is? Well, it's got to be based on the fair market value of the creation, of the printing, of the mailing, other services in connection with the ad itself. You've got to, if it's in fact one party that is the marketer and providing the site itself, you have to charge the other party for their share of the advertising cost as well, in direct proportion to the prominence of the ad itself. Now, there are a number of questions that come out of that, because, for example, if you look at some of these single property web pages, you'll see a property on it, and most of the ad really goes to selling of that particular piece of property. Most of it lays out exactly what a real estate broker, or more importantly, a real estate agent, would lay out in its efforts to sell that particular property. And yet now you have a lender that may co-market on that. You're not simply going to look at the amount of space that's taken by the lender as compared to the little bit of space that's taken where you reference who the agent is on that. You're going to attribute most of that space that goes to the house, you're going to have to attribute that to the real estate side, because that's really what it's for. Otherwise, you're going to run into an issue of defraying costs, which is something that you cannot do. You can't have other third parties, you can't have lenders, for example, that you co-market with, defray your costs and expenses by picking up a charge that you otherwise would be responsible. And that's what that point is right there. No defraying, no discounting expenses can be incurred. So let's move on to the next slide. What else do you have to know in order to have a proper co-marketing arrangement? Well, you really need to maintain and document reasonable procedures to calculate the joint or co-marketing charges and or create a standardized rate sheet if you otherwise don't have that. But you should have policies and procedures. You should be able to look to something when a regulator asks you for it that says, here's what we went through in calculating out how to divide the space up, who got what amount of space, what proportion of the cost was theirs, and this is what we went through in determining what the cost itself is. And that's that next point. Marketing fees should generally be reasonable in amount to the fair market value of the services performed in the relevant marketplace. And if you look at the PHH decision that came out of the Court of Appeals, they went to the question of fair market value, and they said that fair market value was the reasonable value for the services that was otherwise being charged and paid in that marketplace. You also have to ensure that you're conducting due diligence and that due diligence is being conducted on you as well. You have to look at the marketing services providers. You have to make sure that if you're the company that's providing marketing services, you have to make sure you're actually living up to the arrangements, to the contractual arrangements on a timely basis and providing all of the services that you suggested in that contract that you were going to provide. Early on, when MSAs came out and co-marketing started to come out a little bit, a big problem that the government found was there were well-drafted agreements, but the parties to those agreements really weren't following through with that. And when you go through a RESPA audit from the CFPB or any other regulatory agency that has that authority, they are always looking to see what was actually done along those particular lines. Now, before entering into the arrangement, you have to think about how you're going to document that arrangement to demonstrate compliance with Section 8. Very important to do it, because when they come knocking on the door and asking you about those arrangements, you have to say, yes, we're well aware of Section 8 of RESPA, but we're well aware of the fact that if we provide real specific distinct services that are non-duplicative, we can get paid for those services. And here's our policies and procedures to say what those services are and to ensure that we're providing those services and that we're dividing up in the context of co-marketing, proportionally dividing up the costs for those particular services. Settlement service providers that enter into co-marketing arrangements have to have those policies. They have to have those guidelines in place. Now, I understand that sometimes, and someone who's on the line right now actually raised this with me in the past, sometimes you run into issues because you say, well, we're real estate brokers, and our agents are independent contractors, and we don't want to cross that line where we dictate so much of what they can do so that, in fact, they argue that really they're employees, or the government argues that really they're employees. But I don't think that that concern is a great concern along these particular lines. I think it's incumbent upon a mortgage brokerage company to have these policies and procedures in place, and it's the real estate brokerage company, I'm sorry, and it's the real estate brokerage company that makes a determination as to which independent contractors it's going to utilize. And I think it's fine, actually, for you to say, if you are going to be an independent contractor providing services to our company, then in fact you're going to follow our policies and guidelines as they pertain to this particular issue. So what are some of the other considerations that are important in having a RESPA compliant co-marketing or joint marketing arrangements? Well, first, I will tell you this. Endorsements are referrals. Endorsement language, calling someone a preferred lender, being called a preferred partner, that is an endorsement. And in the eyes of the government, in the eyes of your regulator, that particular endorsement means you're making a referral itself. So it's not advertising that you can get paid for if the ad is going to say, go to XYZ lender, we think they are the best lender for you. That's an endorsement, and that's a referral along those particular lines. So that's number one, stay away from endorsements. Number two, exclusivity and tracking. Now we know, and this came up in the prospect case itself, they don't want you simply to have exclusive arrangements when you're co-marketing with others. And that's important to note because as you have exclusive arrangements, the CFPB is concerned that in the eyes of the consumer, you're basically saying these are the right guys. The CFPB really believes that the consumer looks to its real estate agent for advice and guidance, and that that agent is going to send them to someone that they believe is best for them. That's a referral. And referrals are okay as long as you're not compensated for that particular referral. So when you are compensated for something like marketing, or when you're co-marketing with someone along those particular lines, if it's always you and that one party itself, the CFPB believes that the message that the consumer is getting is these are our guys, these should be your guys, go to them. In large part, that is a message you'd like them to get, but for the restrictions of RESPA itself. And in terms of tracking, you can't then track your co-marketing arrangements to see how much business you are getting from the other party. Can you track your marketing to see how much business you're getting as a result of a marketing piece? Absolutely. But if you look at the prospect case and you look at other cases that have come up as well, the CFPB has found in the context of lenders with MSAs and other types of advertising arrangements, the CFPB has often found that on a monthly basis the lender may be calculating their capture rate. And if the capture rate isn't good enough, then in fact they terminate the contract itself. And the CFPB believes that that is indicia of, in fact, referrals. And that forces a company who wants to continue to receive their money from marketing services to make more referrals itself. The third point over here is tangled business relationships. And that is, I see this so much out there. I see lenders and I see real estate brokerage companies well, lenders and real estate brokerage companies or real estate agents and they have a lot of different things going on at once. They might have an advertising arrangement going on. They might be co-marketing with each other. They may have a desk rental at the same time itself. The more tangled those business relationships are, the closer you are to crossing that particular line where what's really happening in the eyes of your regulator is, in fact, a referral. When we structure our arrangements, we tell them, tell us what type of an arrangement you want to have. Don't mix these up with the same parties. Don't make it an all-encompassing arrangement where you're touching every one of these elements so the consumer really can't go anywhere else. That becomes very problematic. Now, fair market value payments, that's always an issue, and the CFPB, yes, they have questioned some of the providers out there that do fair market valuations. They've mostly questioned them because they think they don't do it on a granular basis. They look on a national level when they need to be looking more on a local level for what the fair market value is for certain services that are provided. But in the context of marketing and in the context of co-marketing, you have to look at how the fee is paid, how often the fee is paid, how often it's adjusted, because if it's adjusted a lot and it's not adjusted based on the fair market value being adjusted, it's simply adjusted because you're not getting enough business out of it, you're going to have a problem on your hands. And many times when you talk about fair market valuation, it is in your best interest to get a third party to make that valuation, but you should try to get a third party that is going to do it on a more granular basis than just on a national basis itself. The next point, obviously very important as well, and that's who's the audience. You know, back in 2010 when HUD was responsible for RESPA, they issued an interpretive rule. And it came about because a lot of real estate agents were effectively helping home warranty companies sell their policies. You guys called it a marketing arrangement, but what happened was the real estate agent would effectively get a commission and get paid if, in fact, a policy was purchased. So someone went to HUD's general counsel and said, hey, you know, maybe this is okay because the home warranty services aren't really a settlement service. And she said, no, actually, that's not okay, and I'm going to write an interpretive letter. So she addressed that, but she went further, and she addressed marketing services arrangements and those types of, and co-marketing and other things along those particular lines. And what she said over there is, if you were going to pay someone to market for you, that's okay, even if you're getting referrals from that party, but the marketing can't go to a group of or a specific part of a group of consumers. That marketing needs to go to the general public. So if you're marketing to someone else and you're only marketing to your own consumers, that's problematic because even HUD viewed that as more of a referral scheme, basically telling your business relationships this is the party to go to, as opposed to nationally or more broadly, more generally, telling the public, hey, this is a marketing piece for this particular company. Something to watch out for and something we'll talk a little more about in just a couple of minutes. And finally on this page, you have what I call warm handoffs. You know, and warm handoffs, they come a little differently, and they are very different from marketing, and they're very different from lead sales. So this is where lead sales come into play, but it applies to marketing itself. If, in fact, someone is doing a warm handoff, they're suggesting, we might have a lender for you, and would you like to talk to a lender, and you pass that call over to a lender itself. That is not marketing by any means. You may be a mortgage broker, depending on how you made a determination as to what lender to send that over to, which raises all kinds of state issues and licensing issues itself. You may not be a mortgage broker. You may simply be making a referral along those particular lines. A lot of players in your industry, and generally in the real estate industry, including the lending piece of it, think that warm handoffs are nothing more than leads. I've got consumers over here who, in fact, want to find a lender, and I will look at some information for them, and then I'll do a warm handoff to a lender based on having looked at their information. That's not a lead. That is a referral itself. and that's something that you really have to watch out for. The concept of leads being proper under Section 8 of RESPA is really a list-based concept. You can purchase lists. You can even do this on an individual basis, but becomes somewhat more suspect. You can purchase basic information about someone that may be interested in the product that you're going to sell. Or you can sell, as a real estate company, some information to lenders, basic information. These people may be looking for a house. They may be interested in a mortgage. But that's where it ends. You can get paid for that lead, but you can't endorse the party you're selling that lead to. You can't advertise the party you're selling that lead to if you're going to do that. It's the job of the party that's receiving that particular lead to go out there, contact that consumer, and win the business itself. That's why leads are permissible. The types of leads we're seeing a lot of today are not permissible because people only want to pay if the lead came through, if the lead itself worked, if they get a warm handoff, if they get a good reference or a recommendation or endorsement that goes along with that. That's not a lead, and you have to be able to distinguish between those particular things. Okay. Many, if not all, of the considerations that we just talked about apply when using web-based marketing tools as well. And so this slide talks to you a little bit more about web-based marketing tools. And you know those include online services that allow real estate brokers or agents to co-market with other settlement service providers by way of a third-party service provider's platform. And there are a lot of these third-party service provider platforms that we have seen sprung up in the last year itself. Focus of these platforms is often the real estate property listings based, things like Zillow, Trulia, companies along those particular lines, but that's not always the case, but many times it is. If the platform features geared primarily towards the consumer of one of the two co-marketed parties, that's going to call into question what portion of the ad should be counted toward which party. How are you going to determine the pro rata share? It goes to the issue that I raised for you earlier. If, in fact, you're looking at a co-marketed piece, but really most of that piece is all about the sale of that particular home, most of that piece covers what the real estate agent would otherwise have to cover in its open house or otherwise through marketing, okay? You cannot attribute those parts of it to someone else that is advertising. You can only attribute the pro rata portion of that little advertisement that they may put in there. There's a potential issue if only one type of settlement service provider has access to the platform and has to invite the other. And it's really a big issue. I wrote here that this is a potential issue, but it's really a big issue. It's what I call the gatekeeper issue. So some of these third-party portals will sign up lenders, and lenders may have to pay a membership fee. And lenders can then go to your realtors, to your real estate agents, and they can say, hey, I got a great deal here. I could bring you in on this, and you can co-market with me. Well, if the real estate agent cannot sign up themselves, if they can't get into this themselves, then they are being given something of value by that lender by bringing them into it. And the reverse is true as well. If the real estate agent is the one that brings the lender in, and the lender otherwise couldn't do it themselves, you have that same gatekeeper issue. So remember, then there's a thing of value that's being exchanged. And that becomes problematic because then they're going to look to see what the history of referrals are and what's going on along those particular lines. Okay, let's jump into social media. There's a lot of confusion about social media and what can be done and what can't be done. And if the truth be told, there's a lot of confusion about it because regulators don't really understand it well, and they're not sure of what can or can't be done as well. But regardless of the medium, regardless of the fact that this may be social media, you still have the potential for Section 8 violations, and you have to, in fact, evaluate for that. You have more than simply RESPA to worry about, and we'll get into that in a minute. So what is social media? Social media is really a very broad term. It encapsulates a variety of electronic communications in today's era. And you can see there the definition that's given by Merriam-Webster. I'm not going to read it all to you, but it's forms of electronic communication through which users create online communities. They share information. Popular examples, you know them, Facebook, Yelp, Twitter, Instagram. I'm sure all of your agents are on most of these things. And they allow for interaction. You know, social media allows for interaction with each other's users' platform. And that's a very, very important point, because a lot of what happens through social media moves out exponentially. You react to something someone said on their site, they react to what they said on your site, you retweet their tweet, and then you say, what rules apply to this? Well, the truth of the matter is all of the same rules apply. Advertising rules, for lenders, truth in lending rules, will follow them all the way through itself, and RESPA applies for it. So there may be that overlap. Both business and personal functionality exist on social media, and that becomes very problematic as well, because they may be a personal site that's being utilized, but it's being utilized for business purposes, and that raises some real complexities. Anyway, if you advertise on any social media site, you still have to comply with any of the related regulatory requirements. You're not exempt because it's advertised on social media as opposed to a print ad or simply a single property website itself. Now, these web-based service providers, they allow for additional activities as well, and you know this, these are very, very important activities. Many of these third-party portals provide CRM systems, customer relationship management systems, and tools. And they're really important because some of them mix together. They intermingle CRMs between real estate agents and lenders. And that raises all types of RESPA issues itself. It also raises privacy concerns as to sharing certain information of the consumer, both state privacy concerns, and for the lender themselves, it could raise Graham-Lynch-Bliley concerns as well. So they have to watch out about how the CRMs are used and how they are able to be accessed by other third parties or by people that you are or companies that you are co-marketing with. There are communication functionalities along those lines as well where the real estate agent is talking to the loan officer, but they're not always jumping through the hoops that need to be jumped through by getting permission to find out where someone might be in the process on their loan application, which is confidential and which is protected by Graham-Lynch-Bliley. That is privacy-related information. There are state laws that are applicable to the specific arrangements at issue, the CRA arrangements, the sharing of leads. That's another thing that oftentimes comes out of these co-marketing arrangements and these social media co-marketing arrangements, and that is leads are generated through advertising through this particular medium, and where do those leads go, and who pays for those leads? Today in the industry, we've seen situations where a real estate agent will get the leads, and a loan officer may get those leads as well. So each one is paying for half the fair market value of those particular leads because they're sharing them, so to speak. And that's a mistake because you have to pay for the fair market value of the lead itself. So the question, the analysis really needs to be, what is the fair market value of the lead to that real estate agent? What is the fair market value of the lead to that MLO, to that mortgage loan officer? And each one needs to be paying the full amount of the fair market value. You cannot defray each other's costs if you otherwise have a business relationship where you're sending business to each other. You cannot defray costs along those particular lines. There may be licensing requirements that come into play. When you're dealing with social media, there may be employment law issues because you need to put restrictions on what your employees and what your independent contractors, what your agents can do by way of social media, and yet you can't go so far as to just ban everything they otherwise want to say. So you have to find the right way of limiting your exposure as it pertains to what they say about your operation, your brokerage company itself. And of course, there's document retention requirements and advertising requirements, both on state and federal levels, that you have to be aware of and make sure you're in compliance with. So, I'm going to go into a number of different scenarios and apply what I've just laid out for you guys, but I think maybe we should answer some questions if you have any right now. So let me see what's up here. Will you be able to get the slides? Well, yes, you'll get the slides. Is there anything else here? Here's a question. So does CFPB consider home service contract providers, home warranty service providers, to be settlement service providers? Well, you know, the unfortunate reality is I believe the CFPB does consider them to be that. I also believe that that's wrong. I don't believe that that meets the definition of what a settlement service provider is. But that was the purpose of HUD's 2010 home warranty rule. And in that rule, HUD treated home warranty companies as settlement service providers, and nothing has come about that changes that. Okay. And then you say, much of social media, Facebook posts are free. How do you determine value? And actually, we're going to go through that very issue in the scenarios that we're about to jump into. So I don't think I missed any other substantive questions, but keep on typing in your questions. Yes?
This is Sarah. I see a couple here.
Okay.
Did you answer, to what extent is the broker responsible for supervision of the agent's individual activities, assuming that the broker gave supervisory training on social media? So even if you have a policy in place for social media use, what's, you know, how much oversight can you do or are you required to do?
Well, it's an interesting question only because the agents are independent contractors as opposed to employees. But the answer to that particular question is, you know, ultimately what's being done is being done in the name of the broker. And so the broker does have that responsibility, and the broker does have to, in fact, provide oversight and ensure that its policies and its procedures and its guidelines are being followed. It's not sufficient just to put guidelines out there and then walk away from it and say they're independent contractors. The guidelines are there for a reason. The guidelines are there for them to be followed, and the only way to ensure that happens is by having some type of a monitoring system to take a look at that.
Okay, thank you. We also had a question for recommendations on third-party evaluation companies. We don't have a list of that here, Mitch. I don't know if you have any recommendations that we could send out after the webinar. That's something that we could maybe look into later.
Yeah, so we have lists of third parties that do it. I will send them to you without any endorsement, I will say.
Okay.
And I think whoever is looking should do their own due diligence on it and see who they're comfortable with, raising the types of issues that I'm raising during the course of this hour.
Sure. Okay, then that's all the questions I see for now, but you know, feel free, everyone, to use the Q&A function to ask any other questions that you might have, or you can always email me offline as well, and we can try and follow up that way as well. Okay, Mitch, you can continue.
So let's jump into some of the scenarios, and I have 4 or 5 scenarios for you, and let's see how they work. I'll take you through the scenario, and then we'll talk about things that need to be considered, you know, in analyzing that particular scenario as well. All right, so the first one is pretty straightforward here. You have a real estate broker and a mortgage lender, and they want to co-market together by way of social media. Fair enough. The lender has already created ads to distribute by way of social media, by way of its social media platforms, and offers to add the broker's name, info, at no cost to the broker, so parties are co-advertising on a joint or neutral page. And the lender, in this particular instance, also often receives referrals. It gets business from this particular broker. But it really costs, you know, practically nothing, if nothing, for the lender to have created these ads or distributed, the social media site is there for free in this particular instance. Okay? The problem that we have over here is that parties think that because some of the co-marketing content distributed online can be uploaded for free, there's no cost to create digital marketing pieces or to distribute them, and that online marketing efforts, therefore, aren't subject to RESPA. But that's not correct. There are a number of things to consider along these particular lines if, in fact, you were going to add someone on and advertise them along those lines. First of all, there's this myth out there that there's a minimum cost exception to RESPA. You can pay X amount of dollars or up to $25 or something else along those lines. And that is a myth. There is no minimum cost exception to RESPA. It is under RESPA, it is prohibited to give and it's prohibited to accept anything of value in exchange for the referral in accordance with agreement to do so. And the agreement's just implied. So if the referral's happening there, it's not legal to give or receive anything of value for that particular referral. So you may have a Section 8 violation if you condition the receipt of something, even nominal, on the express or implied agreement. So if you're putting someone, let's say a lender is putting you on their social media site for free, and they say, oh, it doesn't cost me anything, I'm just going to put you up there, but you are referring business to that particular lender, a regulator is going to say that you got and accepted something of value by way of that advertising from that lender, okay, in exchange for those referrals. It may be they say that the lender defrays your costs because otherwise you would be advertising yourself and you'd have to pay for those particular costs. It may be that the social media site has its own advertising scheme and charges for these types of ads, and that broker otherwise would have had to pay to put an ad on that site. Facebook is a classic example of something along those particular lines. Facebook allows business advertising, but most of that is for a fee. And therefore, they're going to find that, in fact, there was something of value that was exchanged in turn for the referrals that you made to that lender or title company or whoever that other party may be. So what are the solutions? How do you handle the situation where they want to give you or you want to just put them on your social media site for free? Well, one solution is to determine the full expense of the marketing efforts. And there are some expenses. It's the creation, it's the uploading efforts, any business advertising, distribution expenses charged by the social media platform. It all may be de minimis, but whatever it is, figure out what it is and make sure they're paying their pro rata share of it. Make sure that that's what's going on. And another thing to worry about over here is you've got to be careful to not limit the audience of a particular ad, because remember I told you about that HUD interpretive rule, which is still good law and it's on the books itself. And it says that if you're advertising or marketing to a limited audience as opposed to the general public, you really are doing nothing more in their eyes than making a referral or an endorsement. There are other concerns about how the materials are distributed and things along those particular lines. My advice for all of my clients is this. The biggest concern you have in the co-marketing context and in the marketing context is this. I told you before that the CFPB and other regulators believe that a borrower or a consumer should be able to look to and does look to a real estate agent for advice and guidance. And they're going to do what the real estate agent wants them to do because they think that's in their best interest. They know it's in the best interest of that real estate agent for this deal to close itself. And so they think that when you're co-marketing with them in any way, shape, or form, you know, many times the consumer is going to pick up an ad or see the ad or see the co-marketing, and they're going to say, wow, I'm going to go to this guy because it is, in fact, the real estate agent that he's standing right next to. And what I tell all of my clients, both on the financial side as well as the real estate brokerage side, as well as title and everyone else is, the way you undercut that argument is you make it clear that what you're doing is an advertisement. Put that little word advertisement in a prominent location right over the ad itself. Just put it right there. It's no different than when you're reading a magazine of a common theme, and then all of a sudden you're going on to an article and you're reading it. It's really the same common theme, but it's a little more sales pitchy, and you look at the top of the page and you realize it says advertisement on it. It's the same thing. And it undercuts CFPB's argument that the consumer believes this is a referral or an endorsement if, in fact, you marked each side as an advertisement. Now, some of you may think, well, I don't really want to do that because I don't know if I'm going to capture business from it or something else along those lines. But I will tell you, I've had clients doing this for probably 2 years now, and I haven't had a complaint along those lines yet, and I don't think it's impacted their business in a negative way. All right, second scenario, okay? Well, the same kind of facts, two parties, you know, a real estate agent or a loan officer or a real estate broker and a lender, they want to co-market together. But this time, instead of giving something for free, as in scenario number one, this time, you know, the mortgage lender to the real estate broker wants to provide, you know, put them on their site and co-market with them at a reduced cost. And this is easy because the answer along those particular lines is you have the same Section 8 concerns that are present. The reduction indicates that a co-market party is not paying its pro rata share of the fair market value, and so you can't do that. If a lender offers space in the co-marketed ad to the broker at a reduced cost, the broker is having its marketing expenses defrayed. And that's a very big term with the CFPB. I've heard it throughout the course of investigations way too many times. It's a very big term. So the costs are being defrayed for that ad, and it's done in exchange for referrals. If there are no referrals that are being made, none of this really matters. Referrals are okay. You just can't be compensated in any way for those referrals. Okay, the third scenario. Same, again, you've got a lender and you've got a real estate broker, and they want to co-market together, okay? But this time, the lender offers to include the real estate broker's ad on its social media page. So the lender may have a social media page. It's not really co-marketing in this particular instance. It's saying, I'll put a banner ad on there for you. Can you put a banner ad on there? And the answer is yes. You can do something like that. And in fact, lenders can have banner ads on your pages, on the page of the real estate broker itself. And that's not a bad place to put it from a lender's perspective, because who's looking at these pages? The general public. It's not just their own customers, but someone that may be looking for a house, someone that may be looking for a broker. That ad, that space on the website is open to the general public, and it's not just looked at by a broker-specific consumers themselves. So it's not a bad place to do it. So the answer to this is, yeah, you can do this, but you got to pay the fair market value of the ad, including any creation-related expenses that go along with it. You have to pay the fair market value. And now it's not a matter of proportionate size that you have taken up over there. Now an analysis is going to be done, and it's best to be done by a third party. An analysis is going to be done really of how many people this ad reaches. How many eyeballs are going to see this ad? Who does this reach? You can't pay for it based on success. No valuation based on success. But you can pay more for it the more and broader the reach itself is. It's the same concept. It's the reason why an ad in the New York Times, which is national and has a wonderful website, or the Wall Street Journal, that as well, is so much more than an ad in the local paper, because so many people are being reached on that particular ad. So that's how you would handle that particular scenario. All right, scenario number 4, real-life scenario number 4. Mortgage lender or an MLO has personal or business social media page where it advertises their own services. The real estate agent's in a position to refer business to the MLO. Independent of any relationship the agent may or may not have, the agent sees the MLO's social media page and decides to interact with it in a favorable manner. This is a big issue. It's a big issue that's being wrestled with by your regulators as we speak right now. And so now you have the agent, and it could be the reverse. I mean, it could be the agent's page, and you can have an MLO, a loan officer that's looking at it. But either way, you want to react to it. So are you going to like it? Are you going to retweet things from it? Are you going to tag it and further their advertisements and their name and things along those particular lines? I'd suggest to you that all of those things have Section 8 RESPA implications. Now, there's nothing, obviously, in the language of Section 8 itself that goes directly to this scenario, because Section 8 was written back in 1974. This wasn't contemplated back in 1974. But it does apply to this scenario. So if you like something, the question is, am I endorsing them? If you like what an MLO has on his social media page, and you put yourself down and liking it, are you in fact endorsing that MLO? And I'm not telling you that you by necessity can't do any of these things, but I am telling you that you have to be very careful about it. The way to analyze this is to see what other things you're doing. Now, if you otherwise have a business relationship with this other party, if you're referring business to them or they're referring business to you, if you have a co-marketing arrangement with them, or if you have a desk rental arrangement with them, or anything else along those particular lines, then more likely than not, hitting that like button, retweeting what they have to say, it's going to give you Section 8 problems. There's no doubt about that. So you have to look at the tangled business relationships that you have and the tangled business relationships that you're in making a decision as to whether or not you want to like something or you want to retweet it. And there are advertisement issues that come along with that as well. You start retweeting some advertisement from a lender, you are going to be responsible for what's in that ad itself. And that can become very problematic because you're talking about truth in lending, you're talking about the Mortgage Acts and Practices rule, you're talking about a lot of very detailed rules and regulations that govern mortgage lender, for example, and their advertisements. All right, so what other considerations do we have over here? Activities that serve to further circulate or distribute the original post, that can be a thing of value in and of itself as well, okay? By redistributing something, you are in fact helping them in their advertising efforts, and one can say that you are in fact defraying some of those advertising costs as well. But at a minimum, even if they didn't say you were defraying those particular costs, they will in fact note that if they're making referrals to you and you're doing something along these particular lines or vice versa, that's a problem because it is a thing of value when you go ahead and you spread someone else's name and someone else's product out. So distribution activities also can constitute an endorsement by an agent. By sharing someone's posts, it typically implies that you're supporting those things as well. And that's the same thing if, in fact, they tag themselves together. So I've never been the kind of lawyer that would say, let's take it to extreme and not allow any of these activities. What I do say to you is you have to take all of these factors into account, and you have to look at the overall picture of the relationship that your loan officer has with that agent or that your company has with that broker, because the more of a relationship that you have in terms of arrangements for marketing, for desk rentals, for lead sales, and things along those lines, then the more problematic it becomes when on social media you do things like share their tweets and go ahead and like it and do things along those particular lines. Okay, let's go to scenario number 5. okay? Here's the situation. The mortgage lender and the real estate broker want to co-market on a web-based marketing tool. We're not talking about social media. We're talking about those, single property sites or something else along those particular lines, something that you might not consider social media. You don't have the same interaction that you would have on social media itself. And the question is, what are you going to look at along those particular lines? So the same thing, the same Section 8 RESPA analysis is going to apply. You have to make sure that, pixel by pixel, you're paying your pro rata share of advertising costs, and you're not defraying or having your costs otherwise defrayed. You're going to need evaluation and determination of the pro rata shares. It may be a little more difficult here because there's potential for variations and complications, especially if they allow others on to advertise as well. Now, I told you earlier that exclusivity is, in fact, a very bad thing when it comes to marketing arrangements and to co-marketing arrangements, and it is a bad thing. But sometimes when you're participating with someone in a co-marketing arrangement, sometimes the best way to be compliant is to participate with one another only when advertising jointly on those particular platforms, because then you don't have to worry about someone coming in and the formula being blown out of water. You don't have to worry about the fact that you have a real estate agent and the real estate agent is no longer paying their fair share of that ad because they've got 4 or 5 other parties over there, and now the real estate agent is effectively there for free because you're paying your share, the rest are paying their share, and the agent isn't paying their own. And that's a problem. And that's absolutely a problem. And I'm not going to mention names of companies over here, but there's a lot of talk out there about ongoing investigations and what the CFPB may or may not be looking at, but that's one of those issues where, in fact, a party or a third-party portal contracts with a real estate agent and then says, and you can go out there and get as many people as you want. You can defray your costs. That's the problem. It should never be about defraying costs. And each party should have their own contractual relationship with the portal provider themselves. And each party should know who else and what else is going to be on there to make sure that they're not defraying the costs of some other party that's on there, like their local real estate agent that's sending them business. That is, in fact, their referral partner, for lack of any other better term. Okay, we just have a little more to go. You have received, Sarah said, do's and don'ts. Those are recommendations for co-marketing do's and don'ts, and so I have them in this as well. You need to ensure that each co-marketing party, this is the dues, pays its pro rata share. We've talked about that. And it's based on a proportionate split, and that's based on their respective prominence in the ad itself. That's what it comes down to. You have to ensure that agreed-upon marketing activity is performed. You've got to look at it, and you have to make sure you're doing your end of the bargain, and that any payment made in connection is fair market service payment, fair market value payment itself. Remember, just because social media platform is free for its users to join or post in certain instances, it doesn't mean that all uses of that platform are offered at no cost. And you can't advertise someone on that platform for free if they are a referral source of yours. You've got to be aware of what may constitute a thing of value, and that is a thing of value. It's not just money. It's a quid pro quo. You give me this, and I'll send you business. Remember, as well, there is no minimum cost exception to RESPA, Section 8. You have to ensure, as we said over and over again, no defraying of expenses. Nothing wrong with co-marketing on a third-party portal, but don't be brought into the third-party portal by a real estate, by a mortgage lender who says, only I can get you onto this. And in those portals that you're on, don't have a situation where you say, only I can bring the lender onto this, because those are all things of value that you're doing. These portals need to open their door if they want to be in this business with your industries, and both parties need to have the ability to contract with them. Then you're no longer talking about defraying one party's costs against another. What the CFPB is really curious about, and what they don't seem to be able to reconcile in their minds, are situations where you guys, where real estate agents and real estate brokers, go ahead and contract for ad space and are given permission to bring others in, such as lenders themselves. And the CFPB says, you know what? You contracted for all of that ad space. This is how much you have to pay. And anyone you bring in, they're defraying your costs. And the only reason they're doing that is because they want your business and you're going to refer that business to them. So it's the inception of the relationship in co-marketing that's really important. That is, in fact, what you want to avoid happening along those particular lines. Remember to keep the term advertisement in a prominent location. It doesn't have to be in huge letters, but put it over the advertisement so a consumer can't say, oh, I thought he was endorsing them. No, an advertisement's an advertisement. Remember to maintain and document procedures on how you're going to calculate your co-marketing charges and fees. Remember to take a consistent approach to all of these things. And consider before you enter into these arrangements how they're going to look. How are you going to demonstrate your compliance with Section 8 of RESPA? Ensure that your advertising, marketing that you're providing for others is to the general public, not just to your own customers. Make sure you're going through due diligence. They're looking at you and you're looking at them to ensure everyone's in compliance with Section 8 and compliance with your own policies and procedures. And remember to take into account any federal, state laws or regs governing co-marketing beyond RESPA, such as advertising, privacy rules, licensing rules as well. All right, sorry about that. I forgot to click through. So here we are. And here's the don'ts. Don't enter into an arrangement with a co-marketing party without getting necessary corporate authorizations. One of the things I see out there is real estate agents and mortgage loan officers, MLOs, entering into arrangements all the time. Now, real estate agents, I understand. They, in fact, are independent contractors, and they certainly have the ability to do that. MLOs in this country today have to be W-2 employees across the board. They need to have corporate authorization for entering into these arrangements. And you're much better off if the arrangements are B2B, business to business, as opposed to the individuals to themselves. It gives you the ability to monitor, gives you the ability to approve, and it gives you the ability to defend the practice ultimately. Don't require or allow co-marketing parties to endorse you. Don't endorse them. That is the death of getting paid for marketing itself, is any type of endorsement, because then you're getting paid for the endorsement, which in the regulator's eyes is a referral. Don't ignore any potential issues with perceived endorsements, likes, follows, repostings. Do what I said. Take it into account. Look at the overall relationship. Look at what it is you want to like and think about what that's saying and whether or not that can be construed as some type of an endorsement or referral. And look at it in the context of the relationship with the party whose site you're looking at. Don't enter into arrangements before considering the implications of any other arrangements you have. So what do I mean by that? You may have a lead sales arrangement. Well, if you're buying leads, you're not going to be able to have a marketing arrangement because, as I said, when you buy a lead, you have to win that business yourself. The party that you're buying that lead there can't send that consumer over to you. But when you're selling leads, you can't send that consumer over to the other party. Whoever's buying the lead has the responsibility of winning the business themselves. So you can't have a marketing agreement and a lead sale agreement, one and the same, because they're mutually inconsistent. A marketing agreement in and of itself is laying out, this is the lender that I'm advertising, where a lead agreement simply says, hey, I'll give you lender information, you go win the business yourself. So take a look at that and don't mix those things together. Don't direct any co-marketing efforts to specific consumers, just to your own consumers themselves. And that effectively means that if you're having email marketing and things of that sort, but they're only going to existing consumers of the agent or the broker, that's not going to cut it if you're advertising someone other than yourself. If it's going to potential new clients as well, that's fine because that's the general public. Don't evaluate or adjust compensation paid under an arrangement based on the capture rate. And don't let the other party do that as well. In fact, the capture rate, it is what it is, but payments that are legitimate for marketing can't be based on success because of RESPA. Don't find yourself in a gatekeeper position. We've explained that before, and that becomes very problematic because the gatekeeper is always providing something of value to the party he's opening up the gate for. Don't perform services for other co-marketing property outside the terms of the marketing agreement. If the real estate agent and the lender are co-marketing, the lender can't incubate or cull leads on behalf of the agent. Now, that's very important because that happens a lot. I see a lot of co-marketing, and then the leads come in, and they go to both parties, and what happens is the lender works those leads, incubates those leads, and then calls up the agent or sends it back to the agent and says, now they're ready to buy a house. That's a thing of value, and I have seen that subject to CFPB investigations that aren't complete yet. So that's something you really need to watch out for. Don't share the cost of the leads, as I told you. Everyone has to pay for the fair market value of the lead itself. And so you have to take a step back, reevaluate your activities and your arrangements. Overall, you really need to take a look at what are the services that are being performed. What's the provision of services that are monitored and documented? Is my valuation right on these things? Does the narrative run true, or could they easily pierce through this and say, no, I'm only getting paid, or I'm only paying because of the referrals that I'm getting? That's what you really have to do. It's a tough area, but it's an area today that, you know, from a business perspective, it's a very exciting area because there's a lot of growth that can come out of this. From a regulatory perspective, from a legal perspective, it's a dangerous area. It's not that you can't do co-marketing. It's not that you can't interact with social websites. It's just that you have to do it right, and you have to keep all of these considerations in mind when you're structuring it. Now, I know we've gone a little over, but I'm happy to answer any more questions that we might have. Sarah, do you see any more questions up there?
Yeah, we have quite a few, actually. And I'm not going to go in order because I think there's one that kind of gets at what you were just talking about, and that is the idea that you're co-marketing maybe on a third-party real estate portal, and you're both being sent leads, and you're working those leads, but then you can't refer business back to each other. Is that kind of correct, is what I was hearing?
Well,
but there's also, okay.
Go ahead. It's not necessarily that you can't refer business back to each other, so let's break it down. Okay. You're working out of a third-party portal, and that portal is generating leads, and so you're both getting those leads. Number one, you both have to pay for the fair market value of those leads.
And
okay?
How do you determine that? How do you determine how much to pay that portal for those leads?
And so fair market value, and the court really came, you know, defined it in a good way in the PHH case, in a helpful way, and that is, what does a similar type lead go for in the marketplace? How much would I otherwise pay for a lead like this from another third-party source? That's how you determine fair market value of a lead.
Okay. And so the lender and the real estate agent are negotiating that separately with that third party. They're determining what they believe to be the fair market value, and they're paying that portal directly, and they might not know what their co-marketing partner is paying.
And they're not, yes, that can happen. Yes, it should happen, actually. And they shouldn't pay half of that. Say, okay, I'll pay for half and he'll pay for half. In other words, the lender can't say, I'll pay for half the fair market value of the leads, and the agent or the broker will pay for the other half. That's not good, because now you're not paying for the fair market value of the leads. The only thing that's happening is the party that is going to get referrals from the other one is defraying the other one's costs. And so whenever there's a sharing of leads that way, the CFPB's antennas come up and say, so here's what's happening. The real estate agent or the real estate broker is, in fact, would have to pay X amount of dollars for these leads. That broker has a relationship with his lender. He's sending this lender business. He's making referrals to this particular lender. And wow, look at what the lender's doing. He's paying for half the cost of those leads. That's defraying the cost of the real estate broker or agent, and that's why that becomes problematic.
Okay.
Okay. Now, take it beyond that, so you may end up with the same sets of leads. Hopefully everyone paid what was fair market value for that lead, right? Everyone should work their own leads. That's what you need to do. It's not, if you're going to refer loans to a mortgage lender, okay, the mortgage lender should not be culling those leads and working those leads for you, because you would otherwise be doing that, and so he's doing a thing of value for you. Everyone should work their own leads for their own purposes. I don't care that they're getting the same leads as long as those are leads that are of value to them and they're paying fair market value for them. But they should be working their own leads for their own purposes.
Okay. I'll just go through a few of these others. Do you mind taking a little more time to answering these questions?
Yeah, no problem at all. Okay,
I know we'd scheduled about an hour for the webinar, but we'll take a few more questions if you all want to stay dialed in. So I have one here. If a home service contract provider is a settlement service provider, then does a marketing services contract relationship need to be disclosed using an affiliated business disclosure statement form, or can there be a disclosure without following the affiliated business disclosure format?
Okay, so I'm not sure I fully understand that question. The only time an affiliated business disclosure needs to be given is if, in fact, there is an affiliation. And that's a control situation or an ownership interest, things along those particular lines. In MSA, a marketing service agreement with a third party that you're not otherwise related to is not an affiliated business. A contractual arrangement is not the creation of an affiliated business arrangement. And so affiliated business disclosures aren't necessary.
So the way that you would be disclosing this relationship to the consumer would be, like you said, when you put the word advertisement on the co-marketing piece, so maybe the consumer has a better sense of what the relationship is?
That's exactly right.
Okay.
That's exactly right. And whenever you're co-marketing, you should put that on that piece. And you should make sure the other party is putting it on that piece as well. So the consumer knows and understands these are not endorsements, these are paid advertisements.
And so there was another question just saying what's the timing of and proper method to disclose the existence of an MSA? And so I think you've answered that. It's just in the advertising itself or in the co-marketing piece itself, you can just be clear about what the relationship is. There's a few more questions. We'll take a couple more. This kind of goes to one of the earlier questions, but if the parent company is funding the ad, is the parent of both the real estate and the mortgage company, so I'm assuming they're talking about an affiliated business, then that real estate company can advertise both of the companies. They would just need to disclose to the consumer the relationship through that affiliated business disclosure process. Is that how that would work?
So you got to take me through that again. You have two companies.
So if you're a real estate company and you have an affiliated mortgage company,
okay,
but that real estate company wants to advertise the services of their mortgage company, they would then disclose their relationship to the consumer through their affiliated business disclosure?
That's right. That's right.
So I think we've covered all of them. Someone's asked for a link to HUD's interpretive rule, and I'm happy to send that out when we provide the slides. Like Mitch said in the beginning, we have some more detailed slides on the background of RESPA itself, and I think that would be really useful to you all as well. So we'll include the longer deck when we send out a recording of the webinar. So if I don't see any other questions, I think we're going to conclude the webinar. Mitch, we really appreciate your participation, and thank you for going over and taking so many of these questions. And I think this is going to be really useful to our members going forward.
That's great. It was my pleasure. Thanks for having me.